Good evening and welcome to Realty Coffee Talk and Awaz Entertainment in Canada around the globe. My name is Tahir Qureshi. I'm your host. Tonight we will discuss multiple challenges at closing a real estate deal, whether it is residential or commercial. It happens and most frequently happens if attention to detail is not given and all the requirement of a lender to send funds to the lawyer has not been done on a timely fashion. What happens if the funding is not received at closing? One side, a seller has already uploaded the furniture, is on the truck, empty the property and ready to move. On the other hand, buyer's lender has not given the funds, whatever technicality it is. Sometimes they have conditions in the commitment to give funding for the closing of the real estate deal. If those conditions are not met, it will delay the closing, and there are consequences for not closing on time according to your agreement of purchase and sale. So when you do a delay closing, one side you have a seller who has emptied the house, put the furniture on a truck in the storage and ready to move to the new location he or she has bought. But the fund they were supposed to receive for the transaction they sold did not arrive, so they failed to complete their purchasing transaction. So not only the buyer had defaulted on their closing, the seller also defaulted on the purchase if they have purchased a new property. Who is responsible for the cost impact it caused? Who's responsible for additional work that the lawyer has to deal with it to do this closing? Somebody has to pay for it because there is a delay, there is a breach of contract. Sometimes you have a title insurance issue. Sometimes the buyer has not arranged an insurance to close the deal, which is a condition of the lender to make sure before funds are advanced, there is an insurance. Lawyer has to get the title insurance. What would happen if there are some title issues on the transaction? So there is a requirement on all parties to make sure they work on those to make sure you don't have a challenges last minute. Now you also have an issue with live and work properties. For example, you have two portions of the property. 30% is commercial. You have seen some condominium townhomes where in the lower level there are commercial features, which is about 30% of the transaction, and 70% is residential. How it will impact the GST, HST? When we do the agreement of purchase and sale for residential property, we totally ignore or neglect that there is a HST applicable for the 30% of the portion. The question will rise, is it applied to the entire value of the purchase or not? When you're doing a transaction which has a commercial component, is applicable to HST. If you do an agreement of purchase sale on a commercial form of URIA, then it already covers that. You will have a indemnification certificate signed by buyer and seller, and everybody file their own tax input tax credit, which is a GST HST report on a quarterly basis or annual basis. They take responsibility. So HST, when we include in our residential agreement of purchase and sale, it says included or excluded. But when there is a residential with in combination with a commercial, you have to make sure the HST is taken care of. So we will be discussing this matter with Sean F. Khan. He's a solicitor and barrister, joining us probably in a 5 to 10 minutes, and we'll ask these questions to him, how it is impacting them when they're doing a deal. We're going to have a continuous episode on this particular subject, and we issues and topics that we'll discuss to make sure consumer as well as realtor have understanding of challenges when you are doing a multiple closing or multiple challenges on closing. Most difficult part is when you are buying and selling at the same time. You have to realize that when you're selling a property, and if you don't have the funds to buy another property, unless your property is sold firm in the same day, if the closing is same day, you will jeopardize the opportunity to close your deal because if your funding is delayed. I think in my previous episode, I mentioned to you one time that we have to sell one and we have to purchase two. And transaction for sale of one of our listing, it went always to 4:30 and we got the funds. Then the seller, our client, they were buying two properties. They could not close two of them because they were able to close one, and second one went to next day. And because of that, truck, they have to incur additional costs for the trucks. So these challenges happen because you are doing closing of your sale and you need the money from your sale of the property to close the purchase that you did. So it's very, very important for you to pay attention to detail to make sure things are done. Secondly, the other thing is to having a bridge financing. It may cost a couple of $100, maybe $1,000 depending on number of days. It's better for the seller to buy and move into the new property, so at least they're not having everything put in a truck and they don't know where to go if the deal doesn't close and have a challenges with the closing. So they're not defaulting on the purchase, but the liability of not able to sell or close their deal goes to the buyer. And this is why we need a legal expert, a lawyer, to explain to us the impact, what happened when you are doing a multiple closing, it doesn't close. Important thing is art of negotiation. If you have a prudent, intelligent, competent professional working with you, especially in real estate transactions, he or she will keep in touch with the entire team that is involved with buying and selling real estate. Because when the transaction has been completed, all the documents normally sent by realtors to the lawyers, respective lawyers, to make sure they have all the information. Make sure the survey is provided, tax information is provided, the ownership of the paperwork is provided. Any condition that you have negotiated in the agreement of purchase are fulfilled. Because if you do not, you create a problem because you fail to fulfill your commitment in the agreement of purchase sale. So this is why. Now GST, HST, particularly if you're buying a new property, for example, we are talking about resale as well as the building, the new construction from the home builder. So when you are signing a certificate that this property is for my principal residence, you are certifying to CRA to give rebate to the builder, because builder is saying is when you buy from a new builder, your HST is included, but they never tell you exactly what that is. So it's very important for you when you're buying from a builder to find out what HST, GST, HST rebate they're going to claim for you. There is a limitation up to $24,000, but some older property where the GST was involved, it may be a little bit more. So this is very, very important for you to find out. If you are buying a commercial property, commercial form says that HST has to be, GST, HST has to be treated differently. So in the commercial, HST is not included, is always extra. Either both of them sign affidavit that I will take care of on the buyer side, and the other person take care of the seller side. So it's exchange hand with the document, affidavit sign, and exchange between buyer and seller through the lawyers. If there is a residential and commercial component in a home, you can see some townhomes where there is on the lower level, this is a retail or commercial component. That is, HST applies to that component. So not to the residential portion. So this is why it's very important to spell out in your agreement of purchase and sale that what portion and how much is HST applicable of the total price that being offered in the agreement of purchase and sale. So when the Shahan Khan join us on the phone, then we'll ask him this specific question. So this is why it's very, very important that you have working with a real estate professional who understand the technicality of these things. They understand what they're dealing with it. They can explain to you. You also have a tax consultant can help you if you are involved. My goal is to next episode to bring someone specialized in insurance related to the transactions in real estate, residential, commercial, get involved. And we can continue this episode on multiple challenges at closing. So we're going to talk about those issues. So this is again is that what happened? Who pay for it? It's become an issue, a challenge for small thing. And bank will never give you the money unless you fulfill the condition. When you have a conditional period and you are securing a financing from the lender, they ask you, please provide this information. If you're dealing with a bank or you're dealing through a broker. I am a principal broker of Canada Express Mortgage, Inc. I can talk about the mortgage. So we have a conditions where the down payment is coming from. Is the money coming from the sale of the house? And is there a discharge happen on the property? Is your line of credit? Have you closed your visas and other commitment that you made to secure a financing? And is home inspection has been done? Is there any significant problems with the house? And what about the appraisal? How the appraisal came out? Who's paying the difference between the appraised value versus the purchase value? Because bank wants to make sure there is an independent verification of the value of the property. So they use very conservative approach to protect their investment. Mostly happens when they don't have any insurance. When you're putting down more than 20%, the bank has no responsibility, bank has no protection actually from the government of Canada because you're Canada Express, Canada Mortgage will not give you the insurance because you are 20%, that's a conventional mortgage. So therefore, they have to rely on the appraisal. Appraisal has to be consistent with the market value of the property. If there is a low mortgage, appraised value, then you have to pay the difference. Let's assume you have a mortgage that you're trying to get for $700,000 and the appraised value came and they recommend $650,000. That means the $50,000 difference in the appraised value, you have to pay from your pocket. If you have firmed the deal, especially when you're doing unconditional offers because you're competing for the property and you have no condition, how are you going to come up with that $50,000 to get the mortgage? Bank wants to see the proof. This is your money. Majority of the bank are not allowing you to draw money from line of credit to use as a deposit because deposit is also borrowed money. It's not your saving. Or a gift coming from family is also, if you owe that money back to the family, so they want to verify your income. They want to make sure this is your money, is saving. Because anytime you borrow money to close a deal, that is a liability and you have to pay back that loan. So bank is watching all that. OFSI rules, as you know, very strict about these things. So it's very, very important for you to make sure you're well prepared and you know that you have satisfied all the condition of the lender before you remove condition or waiving of your condition, the agreement of purchase and sale. Because so far you have a conditional agreement of purchase sale. Now you have satisfied all the conditions, but you still follow up. Make sure 10 days before a notification is sent from a bank or the lender to your lawyer that they're going to fund the project. Then you also follow up again, as fund has been sent to the lawyer or not. So make sure you stay on top of that. So make sure you work your realtor to make sure that all those commitment that you made to repair things during inspection are fulfilled. Copy of the invoices, repair work has been sent to the lawyer, through your lawyer to the seller's lawyer. So to make sure that they know that they can share with the buyer's lawyer. Sometimes, people leave dirty houses and it's looks very bad. It happens when one of our listing. If you have a good relation with realtor, they help you, and I'm grateful to one of my fellow realtors on listing, because we have a family. They were not able to do all the proper cleaning and dispose of things. They left it there, but he was very cooperative. I was very impressed. So helping each other to make sure we continue good relation with them. But it's very important. If you put in the clause, if you don't clean it, we charge you $500 or $600, $1,000. Put in the agreement. That way, they make sure the house is kept clean and garbage is disposed of. These are the things that can cause problem. If you have, sometime people take out things that belong to the property, a fixture they install, you don't remove those small, you're making holes on the wall, and sometimes people have taken the mirror out from the bathroom. How can you take out a mirror from a bathroom? This is one of the few things where we have to ask the seller to put back those mirrors because they are already installed. How come? So we're going to take the call now. Coming on, you are on Awaz Entertainment, and I'm going to pick up this call. This is Realty Coffee Talk on Awaz Entertainment. Hello, this is Realty Coffee Talk on Awaz Entertainment.
Hi, this is Sean Khan. How are you?
Hey, Sean, welcome. Thank you very much for calling in. I was looking forward to you. We have a couple of questions regarding legal challenges, multiple challenges at closing.
No problem at all. Thanks for having me. Can you hear me clear?
Yes, very, very clear. Wonderful. Thank you very much.
Excellent.
So we have this is an episode we started. Multiple challenges at closing is that when the funds are not arriving at the lawyer's office from the buyer to the seller, what happens? The seller has put the stuff on the truck. They already bought another property, and they are moving out to new location, and they needed money from this sale of their property before they buy the property. So a delay happened. Who's responsible for all these costs? So can you enlighten us a little bit about what?
Yeah, absolutely. I think that is a very topical issue. We see this as real estate lawyers a lot more often than we'd like to see this issue. Just recently, we've been dealing with this as well. Now, for whatever reason it might be, recently the pattern that we're noticing is a lot of the individuals that are in breach, they're using COVID and just the whole pandemic as a reason. But there's only so many times you can rely on that as an excuse. And in some cases, that might be the case where it is delaying funding or their applications aren't going through. But what you're referring to and what I'm thinking about here are firm deals where we're acting for a seller, and on the day of closing, we find out that the purchaser is unable to provide the funds for that closing. And now our clients might need those funds that they get from the sale proceeds of their property to then go ahead and close on the purchase property. And it could go on, and it's a dominoes effect, because that purchaser that we're buying from might need the sale funds to then buy their property. So it is something we're seeing a lot recently.
Yeah, because this is the same purpose. I think we had an episode before. This is the same issue. There is one is a delay, is inconvenient. Number two, there is a cost impact involved with this. Who is responsible for that, so you can educate our viewers who are watching Realty Coffee Talk on Awaz Entertainment that cost impact, who is the responsible, who is breaching on this agreement, and what are the consequences for that?
Absolutely. I think that is a phenomenal question, just because it's one that individuals, hopefully not, but they do see this more often than not. And to answer that question, who's going to be bearing the cost? Well, first thing you have to make sure is whoever your lawyer is, they need to inform you of your rights. And how do we do that is we have to refer back to the agreement of purchase and sale and ensure that it's a firm deal. Now, what do I mean when I say firm? I mean that there's no conditions that are outstanding that need to be satisfied. It means that both parties have to honor their contractual obligations. Now, in order to answer your question as to who's going to bear the cost and what happens with regards to the cost, well, it's as simple as who is the breaching party. Now, with most of the cases will happen where the purchaser is unable to provide the funds to the seller on the closing date, and they need an extension. Now, in our practice, if it's a 1 or 2 day extension that the other individual requires, we speak to our clients, and if they don't have movers outside or if they're not desperately selling on the same day, then we say, you know what, allow them the extension as long as it doesn't prejudice my client's rights. But in instances where the mortgage isn't in place or the purchaser is unwilling to close for whatever reason, and our clients being the sellers, let's say in this example, have the movers outside, they have to close another transaction. They have a mortgage on the property that needs to be paid off. These costs need to be paid by the purchaser. In addition to the mortgage per diem charges, you have realty taxes, you have home insurance that needs to be activated if it's been canceled for the closing date because the mortgage is not paid off. So these are fees that, as representing the seller, should the purchaser be in default, you should be trying to get back for your client, and there's more that you could do too, depending on the situation.
Yeah, the challenge is when especially it become more complicated if the seller needs the fund for their purchase. Because if they're using fund from the sale of their property to buy the other one, not only the buyer is breaching on their agreement, but they are breaching on the other property that they bought where they're moving in. So
I couldn't agree with you more, exactly, and that is the issue because a lot of the times, here's what I've started recommending to my clients or prospective clients when they call our office to let us know there's an upcoming closing coming up. Do not buy and sell on the same day. These are issues, practical issues that are associated with it. It makes it a bit more difficult for us as well. And if the other side is not corresponding as promptly or they're not aware of their own client's position, it literally prejudices our client's rights. So what we recommend now is look into a bridge loan. See if you could get some sort of a financing from the bank that will allow you to buy your house first and then later sell your house to pay off your mortgage if you have an existing mortgage, and then to pay off the loan. But I agree with you totally when you say that this creates issues, not only for the individual who's selling their property, but let's say the person, so say it's my client, and they're selling their house, and now their house is unable to close because the purchaser can't fund the deal. And the same clients are buying from somebody else. Now they have two agreements they need to worry about. Now the lawyer needs to kind of work with two different lawyers and to ensure that the other side don't hold us in default. And in practice, I mean, you're very well in your rights to hold the other party in default, but there's a lot of practical issues with that lately as well. We can discuss that in a minute or two. But more so to answer your question, then you're looking at legal fees for the other side that you have to pay, extension fees, hoping that that buyer that you're purchasing your property from isn't buying and selling on the same day as well. Because if they are, now you have four parties involved because of one person's breach.
See, actually, this happened to us. We have a buyer and seller. So each agreement you have two parties. So when you are selling it, you have buyer and seller. You are buying it, you have buyer and seller, and then seller also have bought from somebody else. So it's a multitude of parties involved with the transaction. So it's very, very important to all the parties involved, pay attention to details, work with the team to make sure financially you're not creating a breach where, as you mentioned, that maybe the mortgage conditions are not fulfilled during that condition before closing. You know, when they firm the deal, sometimes there is a mistake done that some condition verification of pay stub income They are not furnished to the employment letter. They want 14 days before closing. They want a new employment letter. They need a two-pay stub. If they're not furnished, they will not give you money, even though a deal has been firm.
Exactly, and it's great that you say that, because this is something that has been happening. It's been brought to my attention as well, without disclosing any names or anything like that. What the trend that we've been noticing currently is, because the market is so hot out there, I suppose you could use that word, and there are multiple offers going on single units or whatever the case might be, a lot of the times agents with their purchaser clients are jointly agreeing not to put any conditions on the offer. Their logical thinking is, if we present your offer with a condition to the seller, they may not wait 10 days for you to waive financing.
No.
So what's happening is they're not even including a financing condition.
Yeah, that's very dangerous. You have a responsibility not only to just get them to sign a piece of paper. We have a Form 129 URIA form that we use as a waiver, but it is not about just protecting yourself. It is about protecting your client, to make sure that they are able to secure funding before, or they have evidence, a commitment from the bank before removing the condition. So this is...
Or going through with it without putting the condition. But the scary part in all of that, before we can move on to the next topic real quick, is the fact that the rationale behind it that's been brought to my attention is the clients that are the purchasers, they're well aware that, okay, if we can't get financing and there's no condition in our agreement, we're going to lose our deposit. So the trend I've been noticing, Mr. Qureshi, I don't know if you've been seeing this as well, is very small amounts of deposits are being provided for a decent amount of a property purchase. So say, for example, you're purchasing an $800,000 property. The deposits that we've been seeing, or that's been going around, maybe $15,000, $20,000. So in the back of the purchaser's mind, they both agreed with their agent that, you know what, if it fails and we can't close, we only lose the $15,000 or $20,000. But excuse me, that's not all you're losing. There's a lot of liability, a lot of fees, and you are exposing yourself to litigation.
Absolutely, because it's a firm deal. That means all conditions have been removed. So that's a very good question. I think, Mr. Khan, maybe next week we will set up a new episode about the role of a lawyer in transaction. We'll talk very comprehensively details about this whole episode. Okay. Now, to continue the dialogue, it is because sometimes people are buying residential with a component live and work properties. As you know, a residential, our URIA form that we use 100, it has APS, it has a HST included or excluded. But when you have a component of commercial which has a retail in the bottom and residential at the top, there is a percentage of the property that belongs, which has a HST applicable, but not the residential side. I was suggesting my viewers to include a breakdown in the schedule A or B, how much percentage of the value of the property is applicable to HST. So what is your experience about that, and how have you done those things to make sure our viewer understand what I'm talking about?
Absolutely, and I think we'll start with the agent that's assisting the potential purchaser or seller in this case. So let's look at it with the way that you're a potential purchaser and you're putting in an offer, or you have a firm deal in one of the live work unit apartments or condos where you have the ground floor as zoned as, perhaps it has to be zoned the right way too, in order to make sure you can carry out that commercial purpose on the floor that is zoned as commercial. So how it's going to work is you'll have your live work unit, and let's look at that example where you have on the street walkout level, you have the office or the commercial zoned area of the property. And above ground, you have your residential area. So what it's going to depend on is your total square footage of the property. So if your square footage of the property is 3,000 square feet, now out of that, you'll have to figure out from the seller and their agents, hopefully they could assist you with that, and get a sworn declaration or get confirmation what is the split between commercial and residential. So it'll go on square footage. So for example, say it's a $3,000 square footage living space. Out of that, 800 to 1,000 is commercial. then you have to put that portion into the purchase price. So say it's $1 million you're buying it for. What would be the equivalent of 1,000 square foot out of that 1 million? That is the amount then that would be applicable to be paid HST on. That's the first step, to figuring out what's the division of the square footage, because residential, you don't have to pay on it. The commercial aspect, you have to pay on
No,
it. And then obviously,
yeah, in this case, I might add that the value of calculation for square footage for commercial is different than the calculation of residential real estate. So the price probably has to be separated in a way, providing a breakdown in Schedule A to show that this portion is so much, includes residential portion, this much square footage equal to this much is for the commercial, just for clarity.
oh no, I couldn't agree with you more. I think if you are able to do that before firming the offer and giving it to your lawyers are really going to appreciate that, because it makes it that much clearer for us. It also makes it clearer for, let's say, the seller's lawyer, because they now know exactly what they need to add onto that affidavit or declaration that they're going to have the seller sign off, saying, I am swearing that this is 25% commercial, 75% residential. It's 3,000 square footage. Accordingly, 25% of 3,000 is whatever percentage you get. And as such, here is the amount of HST you need to pay. Now, when it comes to collecting the HST, you're looking at a different ball game as well.
Correct.
All in all, because now you have an option of saying, you know what, as the seller, we're not collecting the HST. However, we still could be on the hook by the CRA that, okay, you sold a property that has a commercial component to it. Why didn't you remit the HST? So what you do is you get an indemnity and a covenant for HST from the purchaser, saying that, you know what, we're not responsible for the HST. If the CRA comes after us, you as the purchaser will indemnify us, and you and your accountant will remit this to the CRA accordingly. There's benefits for both sides for doing this. I mean, it goes without saying, the purchaser doesn't need to cough up that 13% or whatever the amount would be on that amount of commercial footage for on the day of closing.
Yeah.
So they even can figure out their finances.
Oh.
So there is that solution as well around for them.
Yeah, oh, this is absolutely, and I'm very familiar with that, and I always clarify this so there is no if and but or questions about, because these are the challenges. Sometimes they come at closing that, oh, you have to pay HST, no, I don't have to pay HST, and you know, a cause of concern to potential delay in making a transaction, or creating a conflict that result in a breach of agreement. It may be a smaller portion of it, but the conflict creates a problem, creates for closing is a challenge. So we're going to take a small break. Mr. Khan, can you stay online? We're going to go for a commercial, and we'll come back. You're watching Realty Coffee Talk on Awaz Entertainment. Thank you.
Welcome to City Pro Realty. We are 100% Canadian family-owned real estate brokerage. If you are thinking of buying or selling residential or commercial real estate, think of us. Call us. We are one-stop solution provider for your real estate needs. Our passion is real estate. Your success is our priority. Our commission plans to meet your budget. Your satisfaction is guaranteed. A family serving family. To search for sale properties and free reports, visit www.citypro.net.
अगर आपका ख्वाब कनाडा में तालीम हासिल करने का है या कनाडा में मुकाम हासिल करने का इरादा है, तो आजू इंटरनेशनल का नाम याद रखें। हम आपकी रहनुमाई करेंगे। स्टडी परमिट्स इंटरनेशनल स्टूडेंट्स के लिए, पोस्ट ग्रेजुएशन वर्क परमिट, प्रोविंशियल नॉमिनी प्रोग्राम और यूनिवर्सिटी ऑफ रजाइना में स्टूडेंट्स के लिए कई सारी स्कॉलरशिप्स दिलाने में मदद भी करते हैं और कई सारी सर्विसेज में सहूलियत का जज्बा और मदद दिलाने का मद्दा रखते हैं। आजू इंटरनेशनल को बनाए आपका अजीज हमसफर। आज ही ईमेल करें info@azu.ca या कॉल करें 365-366-3231 पर। आवाज एंटरटेनमेंट के कस्टमर्स को मिलेगी खास सहूलियत। आजू इंटरनेशनल, हमारी कोशिश, आपकी कामयाबी।
Welcome to City Pro Realty. We are 100% Canadian family-owned real estate brokerage. If you are thinking of buying or selling residential or commercial real estate, think of us. Call us. We are one-stop solution provider for your real estate needs. Our passion is real estate. Your success is our priority. Our commission plans to meet your budget. Your satisfaction is guaranteed. A family serving family. To search for sale properties and free reports, visit www.citypro.net.
Welcome to Realty Coffee Talk on Awaz Entertainment in Canada around the globe. We have our guest Sean Khan, a solicitor and barrister online, answering our question regarding multiple closing challenges. Sean, welcome again on Realty Coffee Talk. You're live on Awaz Entertainment. The issue is coming about in terms of challenges at closing is that title insurance. And why the title insurance is important? So can you tell us, have you experienced any challenges in securing title insurance?
Yeah. So when we're talking about closings and then real estate in general, the norm has now become obviously to obtain title insurance because most lenders do require it, or they say either go for title insurance or provide a lawyer's opinion. Title insurance is very concise. Title insurance also covers a lot of problems on title that a lawyer could not foresee at the time. So it has become norm to obtain title insurance. It can protect you from things that you're not aware of, or lawyers cannot search on the title of the property. But title insurance isn't the only sort of insurance, as we know, we would need to obtain. It's a one-time premium that you provide. And if we started talking on title insurance, we'll need one episode just for title insurance because there's so much you could discuss on it. But in addition to title insurance, we would also, obviously, banks require this, lenders require this, is to obtain fire insurance for the property.
Yes.
You'd be surprised, Mr. Qureshi, how many times clients forget this, even though you reminded them, and it holds up the deal until that binder or certificate is issued.
Wow. Yeah, this is, I was coming to, that was my next question about the insurance. You see, according to agreement of purchase and sale, seller is supposed to maintain insurance. And I always advise my client not to cancel the insurance until the ownership has been transferred, because insurance company can retroactively close it one day before because the buying closing date, it belongs to the buyer. So all insurance company will advise you not to cancel the insurance on closing until the deal has been closed. Then you could call them, there is effective that day, you cancel it, they will do it. So it's very, very important to have your insurance, because I think lender document says that you have to provide insurance before they lend you money, because they need to protect their money to lend.
Exactly. And ultimately, if you're a solicitor that's representing both the lender and the purchaser, the bank will go ahead. It's not a commercial deal, so we're talking residential. The bank will go ahead and fund you the deal, and they say, don't you dare release the funds until you have insurance that's sufficient and it satisfies our requirements. And what do? We ask the clients, or we tell them in advance, guys, make sure that this is in place, loss payee as applicable. And to our surprise, if they don't do it, and then you're looking at delays. So there's only so much you could do. At the end of the day, the client will have some responsibility to take as well. Our job is just to make it as easy and as stress-free as possible for the client. But yeah, I very much agree with you with advising your clients as sellers, do not cancel property insurance until you close. So we had an incident where if a deal does not close on the date that it agreed to close on, and the clients have gone ahead and canceled property insurance, well, now you got to call back and get the policy coverage started again, because you're on the hook until the house is sold. You're legally responsible for all liabilities.
Oh, absolutely. This is why we advise people to make sure all your utilities, everything is transferred, but do not cancel until the deal is closed. Give them a tentatively date, but do not close them, because if you are in winter, snow falling -20, -30, and you turn off everything and deal didn't close. What happened? Your house will freeze and you have a damage in the property, who's responsible for that? Because you are responsible until it takes the property is transferred. Now, the last question I have for you is called gap coverage or closing cost. Let's assume there is a delay, there are deal didn't close, or you have a bridge financing, deal didn't close, you did move to the new places. There are so many challenges. What kind of a gap coverage can be arranged, or a viewer can think about it when they are buying or selling a real estate?
I think that's a great question that we do see in practice quite a lot. So let's take this example. So say you are a seller and you've just sold your property and your closing is on a specific day. You've already bought your property because you listened to your lawyers in advance from your previous experience, and you didn't want to buy and sell on the same day. So you've gone ahead and you got yourself your bridge loan, and that helped you close on your purchase transaction. Now, that happened before you sold your house, so technically now you own two homes.
That's
you
right.
still have to pay your mortgage on your first one and pay off the bridge loan. And, the bridge loan will cover your down payment or whatever the case might be. And now what's going to happen is you're thinking everything is good to go. I'm going to close. I won't have the headache I had 2 years ago with buying and selling on the same day. But guess what? Unfortunately, your sale is not going to go through because the purchaser is in breach of their contract and they are not in funds. So now, luckily, you don't have to worry about closing on your house because you've already bought it, but you have other headaches to deal with, such as what you mentioned earlier, utilities, property insurance. If you're in a condo fees. If you're not, then you're talking about mortgage payments. You're also talking about per diem charges on your mortgage. And now some of the banks, what they do is they have a payout statement that's only valid for maybe 30 days or 10 days. After that, and it's very important as lawyers when you're negotiating these extensions, you have to consider these fees because it could be that their extension is more than the amount the statement is valid for. And for the next statement, they'll want further charges. It's the worst in private mortgages because then they're charging you $200-300 for a payout statement. That's one aspect, okay? So we've just discussed that. The other aspect of that is what if you have the bridge loan? These bridge loans, they're not interest-free, or at least the ones that we've acted on aren't interest-free, so you'd have to pay the per diem on that. Who's going to pay for that? Say you want a 20-day extension. These are things you need to calculate, and you need to make sure if you're agreeing on the extension and you know that your position is strong and that the purchaser is in default, you want to make sure your client gets compensated. And lastly, to answer your question, what sort of things can they do to protect themselves is, number one, make the purchaser pay for these fees, okay? If the purchaser agrees, perfect. You can move on and close. If they don't, you have to talk to your lawyer and look at your options. And then lastly, they do have a way of obtaining some sort of coverage, as in an insurance coverage, that will allow you, for example, up to maybe $20,000 or $25,000, the maximum amount could be, in case of a breach that is not your fault, and in case of closing not occurring on the date due to no fault of yours. In this case, the example I've given you, it doesn't seem to you that it's the seller's cost. So then they would be able to make a claim and accordingly be compensated for those losses in that period that's out of their control.
Thank you very much, Sean. You explained it very, very well because these are the challenges very frequently comes to lawyers because they are the one, according to Ontario law, they close our transaction. When agreement of purchase is completed, it is given to the lawyer to do the completion, doing the processing and execution of your agreement of purchase sale. So in the past episode, I recommended that you should talk to your lawyer, have them draft your clauses, make sure they review them during either drafting the offer or during before you firming up the deal to make sure everything is done. So thank you very much, Sean. We're going to be continue to have a contact with you on our multiple challenges at closing, and we will discuss in the next episode, and we will continue this topic. Thank you very much.
Sounds good. Thank you for having me. Have a great night, Mr. Qureshi. Take care.
Thank you very much. Dear viewers, you are watching a Realty Coffee Talk on Awaz Entertainment in Canada, around the globe. Today's topic was multiple challenges at closing. You saw that when a transaction is not completed because of funding, because of insurance, your buyer was not able to provide reason, whatever reason, can close it, don't get the funding, or the lender hold on because certain conditions was not fulfilled, or some mistake or error. It has the consequences, has the impact, not only on the seller, but if the seller needs funds to buy another one, so there are multiple parties are involved. So it's very, very important to pay attention and talk to your lawyer, talk to your real estate professional, talk to your people who are involved with the transaction, stay on top of with the lender, the mortgage broker, to make sure all documentation requirements are satisfied when the transaction has been firmed. So I hope that this will be helpful to you to understand multiple challenges at closing. You're watching Realty Coffee Talk and Awaz Entertainment every Thursday at 7 p.m. We will be continue this episode because we will have title insurance challenges that people are facing and why this cost to the consumer, which is on top of the purchase price. So we'll talk about land transfer fee, how it impacts you, and also if you are in Toronto, there is a second land transfer tax by the city. So we'll talk about this in the next episode. Thank you very much for watching. As you know, the coronavirus second wave has started. Be careful, wear mask, do not keep social distance, avoid the crowds, comply with health guidelines. May God bless you all. May God bless Canada. Thank you very much. See you next Thursday at 7 p.m.